Seems like it's good. I'm just having Morgan check it.
Oh, yeah. Okay.
Hey, good morning, everyone. Mike Salcedo. Good. I'd like to go ahead and introduce Maria Mossaides, the Director of the Office of the Child Advocate.
Good morning. I apologize for my hoarse throat, but happy to report that the COVID test was negative, so it must just be a really bad cold. Good morning. Today, the Office of the Child Advocate is releasing a report on our findings and recommendations following a multi-system investigation into the case of Harmony Montgomery. Harmony was declared missing by the New Hampshire authorities in December of 2021, and she remains missing today. The purpose of our investigation was to determine what happened in Massachusetts and why, and whether the actions or services provided to Montgomery and her family were adequate and appropriate in accordance with agency policies and in compliance with state and federal law. Cases the OCA investigates, sadly, illustrate gaps in our system. OCA's recommendations in our investigative reports focus on policies, regulations, training, or delivery of state services and/or state law can be improved at both the agency and systemic levels. Our focus always is on the children of the Commonwealth, their needs, their rights, their well-being. As you will hear today,
Take a step this way. Towards me.
As you will hear today, our central and most important finding in this investigation is that, unfortunately, and with serious consequences, Harmony Montgomery's individual being and safety were not prioritized or considered on an equal footing with the assertion of a parent's rights to care for her in any aspect of the decision making by any state entity. This report describes the ripple effects of miscalculations of safety and risk and the unequal weight that was placed at multiple decision points across our system on Harmony's parents' rights versus her own well-being. To be clear, I am not here today to ascribe blame to any individuals. Child Protective Service work is the hardest job in government. The OCA's reviews have the benefit of hindsight. Details that appear clear now may not have been as clear at the time the decisions were made and actions were taken. The OCA issues our findings and recommendations today with the goal of advancing systemic reform that puts the needs, rights, and well-being of children first. Before I begin to address our findings and recommendations, I would like to start by telling you what we know about Harmony Montgomery. At birth, medical experts believed that Harmony would never see and that she would be severely disabled. However, Harmony defied expectations. Although blind in one eye, she grew stronger with each passing week. As she grew into a toddler, it was clear that although she had visual disabilities, she had developed superior coping mechanisms as well as a knack for overcoming challenges. Harmony was independent as a toddler and very young child. She liked books, playing with dolls, and playing with other children. She is described as both charming and very active. Harmony had very well developed language skill and was known to be very empathetic. Harmony loved all types of foods, including onions. As a young child, she had the opportunity to play in a vegetable garden and would pick the cherry tomatoes and cucumbers. Our knowledge of Harmony ends at age 4.5, when she moved to New Hampshire to live with her father. From that age on, we do not know what happened to her, nor do we know where she is today. We do not lose hope, however, that she will be found. want to provide some background on the family. This case involved two states, both Massachusetts, where Harmony was born and taken into state care at 2 months old, and New Hampshire, where her father lived at the time that a Massachusetts court granted him permanent custody. For the purpose of this investigation, the OCA is only concerned with the actions that occurred in Massachusetts before custody was granted to her father. These events took place over a 5-year span, beginning in 2014 and ending in February of 2019. Harmony was born in 2014. Harmony was solely in the care of her mother, Crystal Sorey, at the time, as her father, Adam Montgomery, was incarcerated. Her parents never married. At 2 months old, Harmony was removed from the care and custody of Miss Sorey. Harmony spent the majority of the next 4 years of her life in foster care, although DCF attempted to reunify Harmony and her mother twice during this period, once in 2015 and again in 2017. Over the same period, Mr. Montgomery had sporadic contact with Harmony. There were periods when he requested visits, interspersed with long periods of time when he had no contact with his daughter. The OCA estimates that Harmony spent a total of approximately 40 hours over the course of 20 supervised visits with her father, from birth to age 4.5. In February of 2019, a juvenile court judge awarded custody of Harmony to Mr. Montgomery. At the same time, the judge also ruled that the interstate compact on the placement of children did not apply in this case, which meant there was no requirement to conduct a home study review of Mr. Montgomery and his wife, Kayla Montgomery, in New Hampshire. The DCF attorney opposed placing Harmony in Mr. Montgomery's care on the grounds that he was unfit and that Harmony should remain in DCF custody at least until the ICPC home study was completed. Mr. Montgomery's attorney, Ms. Sorey's attorney, and Harmony's attorney were all in favor of Mr. Montgomery receiving custody of Harmony and did not object to Harmony being returned to Mr. Montgomery without an ICPC home study. Approximately 1 week later, Harmony moved from her foster home placement into the home of Mr. and Mrs. Montgomery in New Hampshire. This ended DCF's involvement, as the DCF case automatically closed when custody was awarded to Mr. Montgomery. It would be another 2 years and 10 months before New Hampshire discovered that Harmony had not been seen since November of 2019, 8 months after she moved to New Hampshire from Massachusetts. This case is complicated by the many legal issues involved in a Child Protective Service case. The modern Child Protective Services legal framework began in the early 1970s, when every state adopted a mandatory reporting system for reporting child maltreatment. The goal of the Child Protective Services system is to preserve families while protecting children. In most situations, the best place for children to be raised is with their families. However, there are sadly times when that puts the child at significant risk. As a result, child protection always requires a careful assessment of risk and the need to balance the harm of removal with the potential harm that can come from failing to remove a child from an unsafe situation. We must also recognize that children of color and poor children disproportionately come to the attention of the Child Protective Service system. And these ongoing disparities require our focus and consideration when considering systemic reforms. To remove a child from the parent's custody raises serious constitutional issues about the exercise of state power. Under both the Massachusetts and federal constitutions, the state can only intervene and assume custody when the child's safety is at immediate and substantial risk. The majority of cases that come to the Child Protective Services system fit in the broad category of neglect. Neglect can encompass a wide variety of issues, but it is worth underscoring that the legal standard for removal is substantial risk. In the many cases the OCA reviews where neglect has been alleged, the underlying issue is that a parent's substance use has led to a situation in which a child was placed at a substantial risk of harm. For example, the parent passes out, leaving a newborn baby unattended at the risk of dehydration, or a toddler at risk of any of the many things a toddler might do inadvertently to harm themselves while being left unattended for a long period of time. It is important to assume that cases of neglect are therefore not benign. Children can and have died of neglect. In addition to proving that a child is at immediate and substantial risk, the state must prove that a parent is currently unfit. The word current is important to remember in this case. Our law assumes the possibility of a parent or their situation changing for the better. The state also has the burden of proving that there are no reasonable efforts that can be provided to the family in the form of services and supports that could prevent removal. Decisions in care and protection proceedings, which is what these cases are called, are filed on behalf of children. Although the state must prove the current unfitness of the parent, Massachusetts statutes require judges in making these decisions to also consider what is in the best interest of the child. This legal framework provides context for the decisions that were made in the court hearing in February of 2019 that resulted in custody of Harmony being awarded to Mr. Montgomery. Our key findings. As I stated above, the central finding of this investigation is that Harmony's individual needs, well-being, and safety were not prioritized or considered on an equal footing with the assertion of her parents' right to care for her in any aspect of the decision-making by any state entity. This manifested across a variety of decisions that were made by various actors over the course of Harmony's life. I'm going to first discuss DCF's case management of this case prior to the February 2019 custody hearing. The OCA found that DCF's clinical assessment and case manage focused primarily on Harmony's mother, Crystal Soaring. Harmony's father, Adam Montgomery, was in prison when DCF's involvement with Harmony began. Although he was non-responsive for long periods of time, during the times when he appeared to be in communication with the DCF case management team, they were not able to engage him, except to facilitate his supervised visits with Harmony. No assessment was ever completed on Mr. Montgomery, and he was not held accountable for starting and completing the tasks on his action plan. The DCF case management team, therefore, had little understanding of his family or personal history from which to develop an action plan and from which they could assess his capacity to parent Harmony. We also found that Harmony's individual medical and special needs were not central to the decision-making in her two reunifications with Ms. Soaring. The lack of focus on her needs and the insufficient balancing of her well-being with Ms. Soaring and Mr. Montgomery's rights resulted in significant placement instability for Harmony, as she was moved back and forth between Ms. Soaring's home and the home of her foster parents multiple times. The result was significant reported trauma and harm to Harmony's well-being, in the early years of her life. Moving on to the legal system, I will note that the OCA's investigation was limited in some respects, as much of the information and documentation was shielded by attorney-client privilege. However, the OCA did review tapes of the court hearings and all available court filings and documents. Based on that review, we have determined that Harmony was also not prioritized in the legal case regarding her own care and protection. Neither the judge nor any of the attorneys in the case put Harmony's needs, safety, or well-being at the center of the discussion of custody. There was also no discussion of how Harmony could safely transition to Mr. Montgomery's care once the custody decision had been made. The OCA found that the DCF attorney did not present a strong legal case for opposing placing Harmony in Mr. Montgomery's care. As stated above, there was no assessment of Mr. Montgomery, and this significantly impacted the strength of DCF's legal case opposing placing Harmony in Mr. Montgomery's care. Similarly, Harmony's attorney did not present information on what might be in her best interest. No evidence on her needs, no statement about Harmony's specific desired legal outcome, no argument about what she needed to be safe and to thrive. Harmony's attorney also did not state any opposition to proceeding with custody without an ICPC, knowing full well that DCF was never able to conduct a proper assessment of the Montgomery family. The OCA recognizes that Harmony's attorney was not required to do any of this under the current Committee for Public Counsel Services standards of representation. But we believe that Harmony's interests and safety would have been better represented if they had, and I will discuss this further in a few moments. The OCA found that the court awarded cross-border custody without compliance with the requirements of the ICPC, relying on New Hampshire case law over Massachusetts case law. The OCA believes that the procedures outlined in the ICPC, if they had been applied in Harmony's case, would have helped to address the safety and risk concerns for Harmony when she was transferred to Mr. Montgomery's care. This would have included confirming the Montgomery's family living situation in New Hampshire and Mrs. Montgomery's current sobriety, continued oversight of placement by the New Hampshire DCYF, and ensuring that Harmony was connected to services and resources in New Hampshire, including schools. Recommendations. Based on the findings I have laid out in this report, the OCA makes a series of recommendations primarily directed at DCF, the Juvenile Court, and the Committee for Public Counsel Services. I first want to note that there are similarities between the OCA's investigation into the death of David Almond, which we released in March of 2021, and in Harmony's case. The decision to place Harmony with her father and to return David to his father both took place in 2019. Many of the OCA's 26 recommendations from the Almond case could be applied to Harmony's case. The OCA recognizes, however, that since the 2021 Almond report, there have been extensive improvements in both DCF and the juvenile court policy and practice. This information is highlighted in a report that the OCA released several weeks ago. For this reason, we focus on a series of new recommendations based on the facts of this case. Some examples of the recommendations include that DCF should develop a comprehensive plan to ensure that both parents are adequately assessed and receive the support and access to services so that their children can achieve permanency. DCF must make sure that fathers are provided the same level of attention as mothers. We also recommend that DCF work to improve the quality of its legal advocacy, with a focus on improving training, ongoing litigation support, and supervision of their attorneys. Moving on to the broader legal system, we recommend that the Committee for Public Counsel Services, which trained and certified the attorneys for mother, father, and Harmony in this case, conduct a comprehensive review of the suitability of the standards of advocacy provided for children in care and protection cases, and the adequacy of CPCS's supervision over the quality of that representation. As I discussed previously, we believe that the current CPCS standards of representation should be revised to ensure that the best interests of children are presented to the court in addition to the direct advocacy to support the child's wishes. We recommend that DCF and the juvenile court work to identify barriers to permanency and reduce the amount of time it takes for there to be a final adjudication of adoption, guardianship, or return to parent for a child. Delays in permanency can be extraordinarily damaging, particularly to young children. We recommend the juvenile court and DCF work in various ways to improve cross-border communication and safety practices, including a recommendation on training judges and attorneys on the ICPC, as well as recommendations that Massachusetts continue working with our neighbors in New England to close gaps in information sharing across borders. Finally, we recommend the establishment of a working group to hold in-depth policy discussions on how considerations regarding a child's welfare and best interests are currently presented in care and protection cases, and what changes may be needed to ensure that a parent's rights are appropriately balanced with a child's needs. We recognize that this is a complex issue that requires multiple stakeholders at the table, but we urgently believe our legal system must do a better job of ensuring that the best interests of children is properly considered in custody cases and not outweighed by the constitutional rights of that child's parents. This is a vital conversation that needs to be had, and we hope our colleagues in the executive, legislative, and judicial branches will come to the table for that discussion. When children are not at the center of every aspect of the child protective service system, then the system cannot truly protect them. We do not know Harmony Montgomery's ultimate fate, and unfortunately, we may never. But we do know that this beautiful young child experienced many tragedies in her short life, and that by not putting her and her needs first, our system ultimately failed her. We owe it to her to make the changes necessary to allow our system to do better in the future. And I will now take questions.
You indicate that hindsight is 20/20, and you make many recommendations here, and you say that DCF has made some progress, but do you feel confident going forward there won't be another Harmony Montgomery case?
I think anyone who knows child welfare says that there's never a situation where we will know that a child will not be heard. There are very complex individual decisions that are made. However, we applaud DCF for robustly implementing our recommendations, and we will continue to work with them in monitoring compliance with those changes to ensure, as we review the data on what's going on at DCF, that there are not additional changes to those policies that are needed. We work very closely with DCF on their efforts at continuous quality improvement. And so I don't think anyone who works in this field can say there will never be another tragedy. But unfortunately, with every tragedy, we focus more on things that we recognize may have contributed to that tragedy.
What's your reaction? What's your reaction to what you've learned in this investigation? And are you outraged, like everyone else, that this young girl got caught in all this?
Obviously, we thought this case was important enough to engage in a full-scale, multi-system investigation. What we believe is that Harmony's needs were not prioritized in the court hearings, and that there was inadequate presentation of both her medical, her emotional, and her educational needs. And by not focusing on those needs, that as you will read our full report, you will see that with the exception of the DCF attorneys, all of the other attorneys did not demand that there be an ICPC, did not object to Harmony being returned to a father who, frankly, had never had an overnight visit with her that we are aware of. Yeah, I am a bit concerned about the decisions that were made, a lot concerned about the decisions that were made in this case, but that's why our recommendations are focused on what we believe will make a difference in similar cases in the future.
What about a DCF attorney not presenting any evidence about what would be in her best interest for her to be safe and to thrive? I guess I'm struggling to understand why that would occur and if there are any reforms or recommendations that would prevent that. Is there any justification that you found?
One of the challenges in this case that we talk about is the fact that there were many questions that we would have loved to have gotten the answers to, but the answers to those questions are covered by attorney-client privilege. Both what the client said to the attorney, the strategy that the attorney adopted as a result of those discussions, and the counseling that the attorney may have given to their client. The DCF attorney, we believe, was hampered by the inability to effectively assess Mr. Montgomery. We believe that that inability, that Mr. Montgomery contributed to that inability by not being cooperative in those times when he was in contact with DCF. That led to serious problems. DCF wanted the ICPC done, wanted that home study done because it felt correctly that had that ICPC done, there would have been updated information that only New Hampshire could have provided, because DCF social workers cannot cross state lines to do an investigation. That's why we have the ICPC. And DCF did argue as well as they could have not to continue without the ICPC. But in that court hearing, of which we have all, or the team that investigated, listened to the court tape, no other attorney, not Ms. Sori's attorney, not Harmony's attorney, certainly not Mr. Montgomery's attorney, objected to proceeding without the ICPC. So in that court hearing, only DCF presented information in opposition. We believe that stronger information could have been provided and wasn't provided, and that's why we've made the recommendation for an examination of the litigation strategy in these cases by DCF legal management.
Do you have any insight into why those attorneys did not argue more on her behalf? It just seems like they were just advocating, they were just.
That is the challenge of this case. Unlike other cases that the OCA has investigated, where we were involved entirely with executive branch agencies over which we have full oversight, in this case, the constitutional barriers of attorney-client privilege means that we cannot ask questions about what was said or the strategy involved. So there are questions that, because of that privilege, remain unanswered.
It seems like
Many
every
of the
check and
checks and
balance failed. And I wonder, in your career, what was the most shocking thing that you uncovered in this investigation?
That's a tough question. I will say the most shocking thing was what happened in the courtroom on February 19th. I was surprised that there was not more of a discussion of Harmony and Harmony's needs, especially given the history of the case. Father had not been actively engaged, even though he presented himself as having been rehabilitated. And as I mentioned earlier, we all applaud parents who address the deficiencies they had that caused a child to come into care in the first place. So it is there are lots of parents in this Commonwealth, some who are within the attention of DCF and some who have not, who may have criminal records. A lot of people do crazy things when they're teenagers, but that doesn't mean you can't be a good parent. The question here is, do you have the capacity to parent this particular child? And I will say that our investigative team was disappointed that there was not more of a discussion of Harmony's medical needs in particular, but also her needs for special education. I was surprised that there was not more robust cross-examination of Mr. Montgomery in terms of his self-presentation of his fitness. But if no one objects to what he is saying, leaves a judge very little choice in this matter.
Do you have any idea how long the court hearing was? The decisive court hearing?
I can't remember off the top of my head.
Was it longer than 2 hours or?
It adjourned for a while and then restarted, and that's why I can't remember how long it was.
Yes, ma'am.
So if we're looking at this as truly a systemic failure from social workers to attorneys to, the judge's decision in this case, are you confident right now that safety nets exist for the most vulnerable children in the Commonwealth?
I think that we have enhanced policies and procedures, that the OCA has been privileged to work very closely with DCF in the drafting of these policies and procedures. And they are really good policies and procedures. The OCA is now working with DCF in a project to create risk assessment tools. These are complicated cases. Almost 82% of children who come to the attention of DCF in the fiscal year annual report are maintained at home with monitoring of DCF and with services and supports from DCF. That means you're not in someone's house 24 hours a day. And what we know is the vast number of the cases that DCF deals with are cases involving parents with substance use disorder and with mental health needs. What the Department of Public Health produced this year was data that indicated that a lot of people with substance use disorder relapsed as a result of the pandemic. We know that both in Massachusetts as well as nationally. So I think that we do the best that we can do to put policies and procedures in place that identify risk, that properly assess parents' skills and capacities. We try to provide the broad range of services that will help families stay intact. But there is no one who can say that everything is perfect in the system.
Do you think the legal standard for when children should be returned to their parents should be reviewed?
I will not say that it's the legal standard of sort of current unfitness and substantial harm. Our argument is that the standard for the representation of children, which is based on a either substituted judgment or direct representation, does not take into account the best interests of the child. And we have added in our report a survey by the American Bar Association that indicates that other states have adopted a hybrid or best interest standards. And we believe that if children's attorneys had to comply with that higher standard, then in the court hearing, there would be a presentation of what the child needs in order to be safe and to thrive. Some of those changes have already happened as a result of the changes that the juvenile court made in the bench book implementation coming out of Harmony. So questions about educational attainment and other things are now, weren't in place, unfortunately, in 2019, but now are in place as bench book guidance for juvenile court judges to ask.
What grade would you give the people that were handling Harmony Montgomery's case?
I don't want to grade individual people. The OCA focuses on what we believe is going to improve the system.
So what grade, I mean, not to pin you to it, but,
I'm not going to go there.
well, approximately what grade?
Well, will there be anyone involved in this facing any kind of disciplinary action?
That is outside of the jurisdiction of the Office of the Child Advocate.
Okay.
Do you believe there's a,
This investigation, DCF and DCYF in New Hampshire was on the front end of all of the scrutiny and all of the criticism. Your investigation seems to point to a failure further down the pipeline. And I'm wondering if it seems to you that Harmony was thrown away by the system.
I'm not sure that I would use those words exactly, but when we looked at this case, it was impossible to talk about what happened with Harmony without discussing what happened in the court hearing because of the change of custody. That was the kind of a key decision. There could have been better case management by DCF in this matter. We certainly were concerned that Harmony was 4.5 years old and had not yet achieved permanency, having entered state care at 2 months old. And that's something that everyone in the system owns, right? That this child had spent her entire life in foster care is one of the real serious issues here, because a child who enters care at 2 months old should be achieving permanency no later than 18 months. And here she was, 4.5 years later, with no permanent home and awaiting placement in an intensive foster care placement. And a child who, because of the instability of her life, as it has been reported, was experiencing behavioral challenges. So the issues here could not be addressed without talking about what happened in the courtroom.
do you think there's a cultural problem beyond the systemic and structural issues you're pointing to with DCF?
What do you mean by the cultural problem?
Do you think there's a cultural
Do
problem?
I think there's a cultural problem? I think that there is always the hope that parents will rehabilitate themselves. That's what we want. The goal of child welfare is not to take children away from their parents. The goal is to help families remain intact. And our law, both federal law and Massachusetts law, set timelines in order to ensure that children don't languish in foster care and that they achieve permanency. So what we hope always is that a child will be able to go home. And there certainly current efforts are also to be applauded by the Department of Children and Families at the large number of children who are actually in kinship foster homes. So they're not with strangers, but are in the care of other family members, so that they can continue to be part of their family and grow up in those family environments. So I don't know that there's a culture. I think that one of our concerns is that children's attorneys do not appear to take a robust role in presenting the needs of the child, and that they are more likely to defer to what advocacy of the parents' attorneys rather than provide an independent advocacy, which is why we hope that the Committee for Public Counsel Services will take a hard look at their current standards.
So I'm wondering if the OCA would look into this or suggest that DCF then look into how many children are currently in foster care for a certain amount of extended time, if that's something that you would look at, and also how many children have been sent out of state without an ICPC.
We haven't addressed the second issue, but our recommendations do address looking at DCF of really looking at children who have been in care for a long time, where it does not appear that there is a sure path to permanency.
You haven't looked at it in depth, but do you have any sense if this case was an outlier that it didn't involve an ICPC over state lines, or that's a more common occurrence?
We have provided some data in the report about the ICPC process. I don't have data on that question.
You had mentioned earlier that New Hampshire case law had taken precedent over Massachusetts state law. Why was that if this was a Massachusetts law?
The judge, in issuing his custody order to Mr. Montgomery, articulated what they believed was a constitutional decision. And that decision that the judge made was that because the father was deemed to be currently fit, given the lack of other testimony at that February 19th hearing, that the judge concluded that by ruling that the father was currently fit, they could not then require an ICPC, because ICPCs under the New Hampshire case were not required unless the parent was unfit. Massachusetts case law would have held that because Mr. Montgomery had been declared unfit in an initial care and protection in 2015, that until the ICPC was completed, the ICPC would have provided information on the status of his fitness. Unfortunately, as we mentioned in our report, no one appealed that judge's decision. And the only people who can say whether that decision was correct, the judge's constitutional ruling was correct, are the Massachusetts appellate courts, either the appeals court or the Supreme Judicial Court, which is why we've also asked in our recommendation around DCF, excuse me, reviewing their litigation strategy of making it clear in which cases they will file an appeal in order to develop case law that clarifies some of these complex legal decisions.
How soon do you believe your recommendations have to be implemented, and how long will it take? Weeks or months or years?
I think these are going to be a little bit harder because they involve CPCS, over which the OCA has no statutory oversight authority. I think that what we found in the David Almond case is that the governor immediately committed all of his executive branch agencies to fully implementing all of the recommendations. And the juvenile court itself, as well as the Fall River Public Schools, all immediately committed. The report that we issued at the end of March indicates the progress of those recommendations. One of our recommendations here is that we all need to come together, all of the actors in the system, including key members of the legislature, to think about what do we want child welfare to be in Massachusetts in this current environment. And I think the current environment, and I would be remiss if we did not acknowledge, and this is a really serious issue, that there is disproportionality in child welfare and child protective service systems. That poor families, families of color, immigrant families, are more likely to be reported to DCF. And there, although we have data that indicates that there's disproportionality at the front door and that the aggregate data that we have from fiscal year 21 indicates that there is not an exacerbation of that discrimination once a case is opened at DCF. That these are really important issues in a period where we're really focusing on equity issues. So I think the leaders of the system need to come together and to have some serious policy discussions. And I think those policy discussions are likely to need a relatively, certainly not a very short period of time to come to an agreement about whether statutory changes and other major changes are needed in order to ensure equity of treatment and protection for children in the Commonwealth.
The governor has called for a guardian ad litem to represent all children that go before the courts in care and protection cases. Do you agree with that, and do you think it's realistic?
We definitely agree with that. If the Committee for Public Counsel Services is unwilling to change their standards to include the best interests of the child, then we believe, as we made the recommendation in the Almond case, that before a child is returned, that a guardian ad litem needs to be appointed in order to do the investigation, to ensure that there is, that the placement is a safe place for a child to be returned to. The governor's recommendation goes farther than the OCA's original recommendation in Almond, but we believe that guardian ad litems are needed. We understand that there has been concern about the number of people that might be available to perform the guardian ad litem function. Guardian ad litems do not only need to be attorneys, they can be qualified social workers. I believe that we can go out and recruit a group of individuals, they can be properly trained, and that we can have a cadre of guardian ad litems certified by the courts that also represent more equitable distribution of people's lived experience as GALs, ability to respect individual cultures, able to speak languages of families that they're investigating. So this, I believe, is another opportunity for us to do a better job for the children of the Commonwealth.
If you had the ability to ask that juvenile court judge who awarded custody to Adam Montgomery, New Hampshire, a question at the end of your investigation, what would you want to ask him?
That's an inappropriate question, so I'm sorry, I'm not going to be able to answer that.
Was there ever any consideration of keeping Harmony with any of her siblings, as far as you can tell, within either the social workers or her attorneys?
At the time that Harmony's custody was awarded to her father, she had a half brother. There was a half sibling. However, the law prefers custody to go to as full a blood relative as can be found. And in this case, what appeared to be a rehabilitated Adam Montgomery would have, under current law, both state and federal law, been the preferential placement for Harmony.
Have you taken any steps to educate the public on the importance of permanency?
The permanency, I think, is a legal concept that we focus on all the time. The OCA reviews cases every day of the week through both our complaint line, the critical incidents that we report, and the cases of substantiated abuse in residential facilities and licensed child facilities that we oversee. We intervene in cases all the time, and we provide feedback to agencies and make recommendations on individual cases. The number of cases that we publicly release is much smaller than the number of cases that our staff deal with on a weekly basis. So on a daily basis, we are focused on permanency and raising a child when a child's case does not appear to be moving in a way is supportive of their well-being. And again, this becomes a serious constitutional challenge because parents, under the law, have the right to raise their children unless very substantial harm has occurred or substantial harm is imminent. So that's a pretty high threshold that needs to be met. And just to be clear, the Department of Children and Families does not take children into custody without a valid court order. So within 72 hours of DCF taking emergency custody, that decision needs to be ratified by a juvenile court judge in the Commonwealth of Massachusetts. And so DCF needs to be able to present enough evidence that shows substantial harm in order to maintain custody before the trial on the care and protection actually occurs.
A very boring clerical question here. So, has this been, how long has this case been under investigation? Was it prompted by Chief Justice Budd ordering it?
No, actually, the OCA, I would say, like the State Ethics Commission, reads newspapers. And so when we first saw this reported in the press and recognized, or the press indicated that there was a Massachusetts connection, the OCA quality assurance staff immediately pulled up the case and read the case. And we made an immediate decision that we needed to do a fuller investigation. So our investigation started probably within the first couple of days of the public press release. We didn't make that announcement as we pulled all of the documents that we wanted to review, but we were pretty quick in requesting both the court file and the court tapes. That is one advantage that the OCA has, which we have full access to individual cases in the juvenile court.
Who failed Harmony?
The system failed Harmony. That by not placing her needs at every decision point, at the decision points of continuing trying to return her to her home, to her mother's home, I think DCF really tried to support Ms. Sori in her trying to overcome her substance use disorder. And so they tried to give her multiple chances of being reconnected with Harmony. And I think that those decisions were made. And then shortly thereafter, I think there should have been a decision about a permanency plan for Harmony. At that point in time, Adam Montgomery was nowhere to be found. So we can't guess what would have happened. The what ifs don't count here. What counts are what actually happened. But if at every decision points about the foster care reviews, when decisions were made at the permanency planning conference about what was in Harmony's best interest, and then clearly in the representation by her attorney and the representation that happened in court, no one focused on Harmony, this beautiful little girl, and what she needed. There were medical concerns, there were behavioral concerns. She needed her special education. She had been in early intervention. For a child who was visually impaired, in order for her to understand the world, she needed all of these supports. And yet no one in that February 19th hearing said, how is she going to continue to get the medical support, the therapy that she needed? How is she going to continue in special education? It's just what she needed in order to be able to succeed in school and to understand her world. So it wasn't just one decision. It was a series of decisions that did not place her at the center and therefore made poor decisions about the risk that she was going to be facing.
Are there other Harmony Montgomerys out there that we don't know about today?
I hope not. If there are, we certainly get critical incident reports of the death, serious injury, and serious emotional injury of every child in the Commonwealth across every human service agency. And those are reviewed every single day. It's probably the first thing I do in the morning and the last thing I do every single night. And let me tell you, that my staff will indicate where I call and say, I need this information right now. They're used to those late night calls or early morning calls. So we take the responsibility of oversight at the OCA incredibly seriously.
When she was placed multiple times back with Crystal Sori and then removed again, was that because Sori was suffering relapses or? Yeah. Okay.
One of the issues that I think we need to address, should we be able to pull together this working group, is the complexity of relapse. We have our own data in Massachusetts at the Department of Public Health that indicates what the pattern of relapse is. And I believe that that information also needs to be taken into account both by our Department of Children and Families and by the juvenile court in making those decisions. Because relapse, when you are suffering some form of substance use disorder. The challenge here is, what do we know about relapse, about how it happens, the likelihood that you're going to relapse? How do we take that into account in terms of making the risk assessment for children? So this is one of those issues that definitely needs to be on the agenda. And I know that our own Department of Public Health has data that will help us figure this out.
In your assessment, is the threshold for removal, which is similar in New Hampshire as well, at the right place? That's a hard concept for the public to understand. People were shouting for, why wasn't she removed sooner? Things like that.
The threshold for removal really is a constitutional threshold, right? Because it has to be that high for the state to interfere with the parent-child relationship. So it's a constitutional decision that you have to prove either abuse has occurred or imminent serious abuse. And that's not going to change. I mean, that's built into the Constitution. I think what we can do a better job is in the analysis of the return home. And I want to be clear, because I don't want to be accused, as I expect I will be, that I'm interested in not returning children to their families. Nothing could be further than the truth. The OCA is actively involved in the redesign of family support and stabilization services so that we can ensure that families get what they need, so children don't have to come into care. But I think that given that so many of our cases involve substance use disorder, that I think that we need to do a better job of planning for that transition home. Imagine you have not had custody of your child or children. Let's say it's 3 children in 2 years. And you go from one day having no children in your house to having 3 children in your house. So that leisurely breakfast is now gone because you got to get lunch ready, you got to get 3 kids dressed, you got to get them out the door, okay? And oh, by the way, one of them's sick, so you're up half the night. So that transition home, according to child welfare specialists, I'm an attorney, not a social worker, but I rely on my clinicians. That return home is amongst the most challenging periods, and the most risk period is a return home. The Office of the Child Advocate wants to figure out how we can guarantee successful reunifications with no repeat maltreatment. That's the goal, right? And I think that we shouldn't be fighting with each other, and we should be focusing on what is it going to take for us to do whatever it takes to guarantee the successful reunification of children with their families. I ran an adoption agency before I became the Office of the Child Advocate, Commonwealth's Child Advocate. And let me tell you, there was no happier day than my staff were able to get a child to achieve permanency. And we were able to get children achieving permanency at age 17. We had children with disabilities that I never thought would find a permanent home and that I feared would spend the rest of their life in care. And yet it happens every day. Social workers dedicate their lives to making sure the kids are safe and that they're with proper families. And in this Commonwealth, where we invest a lot of money in comparison to the other states that we deal with every single day, the other OCAs, we are very generous to the families in terms of the amount of money that we spend in support. So we need to sort of spend that money smartly and make sure that we're focused on the risks to children. So we don't have a situation where a year from now, I, as the child advocate, is presenting another investigation on a case that was not handled the way we wanted it to handle. Thank you.